So what is the difference between a successor trustee, an executor, or also known as a personal representative in the state of Michigan? Hi, my name is Mike Rutkowski, estate planning and elder law attorney. And today we're going to dive into the difference because the difference lies in what document are we talking about? Are we talking about a will where we're then talking about an executor or a personal representative? Or are we talking about a trust where then we're talking about a trustee? So let's jump into both of those. Let's first start with the will. Under a will, an individual has the ability to say who's going to take care of all this stuff after I pass away. One clear difference though you have to acknowledge is that this only happens after passing away. Where in a trust, there can be other times where a successor trustee must act. So you've passed away, now a will has to go through the probate process. A lot of people don't understand that now we're going to submit this will, this document to the court as evidence of what our wishes were while we were alive. There's a lot of reasons why a judge might not accept a will, and we're not going to get into that today. But in a will, a very important part is who's going to take care of this when I'm gone? And that's referred to as the executor, or also under Michigan law, being a Michigan attorney, we call it a personal representative. Under the will, there's a priority of who can act if maybe a personal representative wasn't appointed. Things that come into play is your relationship with the individual. Are you a spouse or a child of that individual, a beneficiary? Were you ever appointed as a financial power of attorney by that person? That's always great evidence of what that person's wishes might have been while they were alive and able to make those decisions for themselves. So then it's that person's responsibility, that executor or personal representative, to just follow the rules of the will. And they're going to submit a lot of things to court. Again, court's going to take a lot of time before we can make those distributions. But both a personal representative and a trustee, their job is to just follow the rules under the document. Whether it's a will and follow the probate court's rules, or it's a trust and you're following the trust rules. Now, something to make sure you understand the differences here when we're talking about a successor trustee. Typically the grantor, which is just a fancy word for who created the trust, they act as trustee while they're alive and able to do so. Then after they can no longer act, and this is where it differentiates from a will, they can no longer act, maybe because there's a period of incapacity. During the aging process, they're suffering some type of cognitive impairment where they can no longer act. Under a trust, you've named who are going to be those successor trustees, and those successor trustees can actually help you during your lifetime versus a will, which is only after death. Typically in both documents, you're going to name a list of successors. You're going to name, first my brother Bob, and then my sister Sally after that, and I'm just making these up, but you get my point. You have the ability to name those people. Let's say you have 3 kids and you just go oldest first. If the oldest can't act, then the middle child. Then if the middle child can't act, then the youngest. So those are the biggest differences between a successor trustee and a personal representative. The successor trustee also has the ability to protect your assets because they're held by a trust. That's a whole nother topic we'll get into another day, but just know that it depends on what document we're talking about, a will through the probate process or a trust which doesn't go through the probate process, and those are your successor trustees.